All right, let's wrap up this week's testimonies of the Senzo Meyiwa trial. We are now joined by legal analyst and regular guest here on our show, Mpumelelo Zikalala, who's also an attorney at Zikalala Attorney. So it's always a pleasure to have you on the show. Thanks for always giving us your time. I think you need to unmute yourself.
I can hear
Yeah, we've got you.
Can you hear me?
We've got you. Thank you so much. All right, let's talk about, I don't exactly know where to start when it comes to everything that happened this week, but I think I want to start off where we ended off the last time you and I spoke. And I was having an issue with the fact that it seems that the defense is not placing the accused anywhere else. And I think I had said to you, listen, if I'm representing an accused, I'm going to say, my people weren't there. This is where they were. It seems even now that as strong as the team of the accused may be, the advocates who represent the accused, as strong as they may be, I'm still not hearing that, no, these guys were actually here, not here.
I think we're sharing the same sentiments as the judge, which is why at a later stage the judge was then saying, but you're not placing any record which is opposite to what the witness is saying. There's nothing which is disputing that the witnesses, they were accused, were did at the scene of the crime. Maybe when it comes to accused number 3, 4, and 5, they would come on a much more positive note, or a much more stronger note of saying that my individuals was not there. You did not identify them. There was no way in which they were able to communicate. But we have to remember, it is not the job of the accused to prove their innocence. It's the job of the state to prove that they are indeed guilty. They participated in the whole act. They acted in concert with one another. They knew exactly what was going to happen, and that is what we call a doctrine of common purpose. Yeah. Which is why cell phone evidence is important. The manner of communication is also important, and the manner in which they do things, and all the other stuff which are going to link them together is also considered to be very important.
Yeah, I mean, I understand, even if, the state does bear the onus of proof, but can one deduce, all right, on the side that, we're not being presented with an alibi simply because there actually is no alibi?
Maybe we need to separate the accused. Maybe for accused 1 and 2, they may seem to be in a bit of trouble in terms of their alibis. But for accused 3, 4, and 5, they seem to have some hole of saying that we are not there. Everyone speaks about 2 individuals that were in the house and not 5. And there are certain scene witnesses, or people that were there on the day, that are saying, accused number 2 is the person that you identified. He had dreadlocks at the time, and indeed, there is proof that he did make up his head in that particular sense. So for accused number 1 and number 2, it does seem that they're not providing with an alibi, as you are stating. It may come back to bite them at a later stage if it can be proved that indeed you're in that house, and if their fingerprints are indeed found in that particular place, and they can't explain why the prints are in there. But when it comes to accused 3, 4, and 5, it seems for them their alibi is quite strong, and what is linking them to this whole process may have been the cell phone evidence that was shot down earlier this week. No, they seem to be on the innocent part.
Yeah. Do you view it as problematic that evidence given by witnesses in the first trial as opposed to this second trial may be different, and then also comparing it to the statements that they had made to police? I'll tell you why I'm asking this, because I want us to also focus on Zitwala's inconsistencies.
Well, I always come up with this notion of saying that the truth is the truth and this is the truth. Yeah. Meaning, whether you've written it down, as long as you've said under oath that what I'm writing here is the truth, whether you're stating it under oath the first time and whether you're repeating it now, it must remain as such. What can happen, though, because we're human beings at the end of the day, is that the manner in which we put things and we phrase our sentences may be different. However, the merits and the core stuff or the core evidence must then remain the same. Yeah. If there are glaring inconsistencies, then the question is, when exactly are you lying about this matter? Are you telling us the truth now? Why should we believe what you are telling us now? If you are a person who is forgetful, then let's not place too much probability in what you are in the evidence that you are providing to us. And the court, yes, should note it, but should not place any weight which is of significant nature, because you are a person who is not able to remember what is there. And then also look at the probabilities of what you are stating. If it's probable, yes, maybe the chances that it occurred is there. But if it's not probable, then you are definitely misleading the court.
And I mean, how do we decide which witness we choose to believe? Because I mean, if we look at the way that Zandile's testimony went in comparison to Thokosi Zitwala's statements, there were some contradictions, and some of them I think might have been actually quite glaring.
In fact, there are. If you are going to find a person who's going to say, yes, I was chased by someone who was chasing me with a knife, and other individuals who were in the same house as you are, they're saying there's no knife that was there, no one was chased out of the house, they simply came in, shot the deceased, took the phone or took whatever that was there, and then they left. It's one of those glaring instances of glaring questions that I then going to say the evidence that has been provided by the state has been so inconsistent to such an extent that it's impossible that people who are in that particular house, 3 or 4 of them, would come to this court and say something which is so clear. Out of all the 3, some of those individuals are definitely lying. So the court is going to say, out of all the witnesses that has been provided, how many witnesses are saying something which is more or less similar? That's probably what happened on the day. Now, let's look at whether, for the second part of it, whether any of the evidence in which we are finding as common cause or common between the evidence has been provided, which places the 5 accused in the scene, as it has been stated earlier. So if there are fingerprints, if there are cell phone records, if there are proper identifiers that have been conducted, then you can more or less conclude and say it's impossible that 3 or 4 individuals will come and say something which is so consistent and that places you at the scene of the crime. The chances are, the probabilities are, you are definitely there on the day, and there's no other conclusion or that you can be able to come up with. Maybe on the defense's side, if you don't even have an alibi of saying that on the day this is where I was, then you can come back and say the accuracy of the evidence which is being provided by the witnesses is still there. However, when the court looks at this at the evidence, it's got to look at the evidence in its entirety, not in piecemeal approach. So you say, this is a bigger piece of the puzzle. I'm piecing together these pieces one by one, but after identifying whether they fit, they're probable or not, are they credible or not, and what weight must I place. And if at the end I've completed a complete picture, then you're going to find the accused guilty. But if at the end of the day, there are loopholes or pieces which did not fit properly, and there are holes in the bigger picture that you are trying to complete, you have no reason, you have no other choice than to find the accused not guilty.
Yeah. You'll tell me what stood out for you this week, but I'd like to actually start with what stood out for me, and maybe we can discuss that. I realized that Longwe Twala was removed by one of the witnesses from the scene of the crime altogether when Senzo Meyiwa was shot and killed. But then there was an SMS which was read out in court that Longwe Twala apparently had sent to, if I understand correctly, one of his own relatives, saying that Senzo has been shot dead right here in front of us. And that's obviously, over time, there was this understanding that, yes, he was there. And now to have him removed from the scene by one of the witnesses was a bit bizarre. What did you make of that? And what does it do? I think, for the defense's case, that, they might have been relying quite heavily on the fact, and I think at some point it was alluded to that it might have been Longwe Twala who, in fact, fired that shot. What does it mean at this point?
From the side of the defense, they're certainly going to sit on it in one of the submissions that will be made at closing arguments, in terms of saying, let's look at the inconsistencies that are there. A person would have much more clearer recollection of what has taken place when that particular event has taken place. So whatever that you wrote on that SMS on the day, there are greater chances that you must place that it is probably something that happened in an accurate manner, or in a manner in which the sequence of events followed. Yes, we're not under oath, something that we do not take into consideration that much, because the only evidence which is considered by the court in its entirety, and in looking within the binoculars or putting it under a microscope, is evidence that has been provided under oath. But it does increase the probability of saying that you may be lying now, you may be speaking the truth earlier, because your remembrance or your manner, your recollection of what has actually taken place would have been much more clearer at the time the incident has actually taken place. Now come and answer to us, or give us an explanation of why did you write that particular SMS. So when the defense is wrapping up its case, then they're going to say, you've brought in witnesses here as a dominant splitters state who are not consistent. They claim to be in the same house on the same day, the same sequence of events happen in front of them, but they have very different recollection of what has taken place. Even on the court details, there's nothing in which he's able to link these two individuals or the accused that are in the witness box. So the court will have to find them not guilty because the witnesses are not credible at all.
Yeah, and what is the penalty for a witness who isn't credible? Because it seems that anyone can go to the stand and say whatever that they feel like saying, lie if they need to, and it seems nothing then happens. I mean, the fact of the matter is that between the two, whether we're looking at Zandile Khumalo or we're looking at Ntokozi Sitwala, somebody's lying, or someone is exaggerating the truth or simply embellishing. What then happens in a case like this, especially at the end of it all when it comes out that these were clear lies by one of the witnesses?
What happened is that at the judgment stage, the presiding officer, there are some that would say, we are not finding the evidence that is provided by this witness as being credible. Then once you've gotten past that first leg, the next thing that you must do, the NPA, is to charge them for perjury, which is lying under oath.
Yeah.
So the one thing that may be difficult would be, what was the correct sequence of events and what is the correct statement or evidence that ought to have been given compared to what they have given. And if it's found that it's two conflicting statements, and even if you admit that you lied under oath, then you can be charged for perjury. Let's remember the crime or the offense in which Matabile was charged with. So there is a sentence that's imprisonment that you can go under, or even a fine, or even both. So it is quite a serious process in which I think maybe the state has not been using that particular process in a much more efficient manner, because you also need to send or teach a lesson to members of the public in terms of saying, if you are going to go to court when we're entrusting you to tell us the truth and you don't, there are consequences which are going to follow. It may include imprisonment, it may include the fine, it may include both. So we are warning you that you are not going to take these things lightly at the end of the day if we end up losing this type of matter. So the day the state starts to take these particular processes seriously, I think it's the day in which they will start to get more credible witnesses when they're being called to answer or to give evidence in court.
Might it also be a situation where there's an attempt to kind of save the courts from having to deal with these kind of matters? Because we all know that our courts are so overburdened.
It might be, but at the end of the day, a crime is a crime. Once an offense has been created, it's the duty of the state to make sure that they're able to prosecute. You do it for a number of reasons, but the very important one is that you want to send a very strong message to members of the public to say, do not engage in this particular process. Let's look at the losses that take place by simply individuals going to court and lying. It's the state resources when it comes to investigations, the state resources when it comes to conducting this particular trials, and at the end of the day, there's no conviction which has been obtained. You may even find that in certain instances, there are going to be civil litigation which is going to follow after. So due to one individual lying and not telling the truth inside the witness box when they ought to do so, you find yourself in a bigger load of trouble. So at the end of the day, the state needs to step up a bit and say, make sure that you are able to find witnesses which are credible. Make sure that if the witnesses have transgressed, they are punished in a manner which is going to send a lesson to members of the public.
Yeah. I heard the judge asking about the importance or relevance of certain questioning by the defense. Two questions I remember in particular was he was asking about, is it important, how many gunshots were heard, how or where the body was lying. I think one of the witnesses was in pains to explain that, if I say that the body was lying in the kitchen, it was also lying in the living room because the house is so small. Is there an importance really in all this evidence? I mean, it's common cause that yes, there was a body, it was in the house, lying in the house, that he had been shot. As to how many gunshots were heard, we also don't know there. Some saying twice, thrice. I mean, is it important? I think that the judge was really trying to ask, why is this important?
I think it is from a perspective of saying that One of the things that when a witness goes into the witness box, we want to test is, are you able to recollect correctly? Are you consistent in your answers? Is the evidence that you are going to give in line or consistent with other independent evidence that may come in? Let's take gunshots, for example. If there are 2 or 3 gunshots that have been heard, on the forensic side, how many shells were collected? If that is consistent, that means that you have a credible witness who's able to recollect correctly what exactly happened on the day and is providing the evidence. So that the question then is, or the assumption would be, why shouldn't we trust the evidence that is being provided by person X if their recollection is so accurate that they even remember how many shots were fired? The same would apply to where the body was lying. You need to have a better understanding of where the body was found so that you can be able to see that you are not concocting something that has been read now in your statement as you're preparing to go into the witness box. You are recollecting and regurgitating the sequence of events as you remember them, and your memory is so accurate to such an extent that we cannot doubt whether you can be able to remember or not. Remember, what we are looking for is only the truth. And the only way in which we can find out whether you're telling the truth or not is to ask whether the sequence of events in a number of ways, but all that you are looking for is the same type of responses, the same type of sequence of events that have taken place. And even if there are glaring or differences that are going to be there, it shouldn't be hardcore or the differences which are going to render the evidence that you provided earlier as if you were lying. So the more consistent you are, the better.
All right, let me ask the converse of what I earlier asked when it comes to the defense, where, when I was speaking about not being able to place the accused elsewhere but the scene of the crime. Let's talk about the state. And you've said this continuously, that, they have to prove beyond a reasonable doubt when it comes to a criminal case. But could you say that the state is succeeding in doing so? Because, one would think that at this point we should be able to say, oh, come on, this is clear, this is obvious, these guys did it, everything points to that. One can't say that yet, can we?
Not at all, but I think what the state is doing is that they are identifying the finish line. They are starting the race, but they're not getting there. There's the little information which then is required so that they're able to complete their line of questioning. They're able to complete the manner in which the sequence of events is supposed to flow. There must be a story in which you can be able to tell, because that's the nature of life. Whenever you are to recollect what happened yesterday, there's going to be a motive, some emotions which are going to take place, and some motive which is going to be there. Let's take cell phone evidence, for example. Once you've been able to prove that there's a line of communication between the parties that are there, then prove that the line of communication existed before, it even continued after the death of Senzo Meyiwa. But most importantly, just make sure that you're able to place those individuals within the house. So it doesn't help you if one of the accused was in jail at the time and did not have access to their cell phone. It doesn't help if the photos which are identified are not that of the accused that are there, because what you are then doing is that you have established a line of communication, but you're not linking that line of communication to the accused that are there. And the importance of those line of communication is that it's independent evidence which cannot be altered by anyone, which is obtained and extracted by an expert, which is there to assist you that the individuals that you are talking about knew each other, they were acting in concert or under the doctrine of common purpose, their motive was very clear. If you do not continue stating that punchline while you are giving that evidence as a state, you are going to find a situation where even after all the evidence that you have provided, the judge is going to say, I still don't understand what exactly happened on that day. Remember the example that we used earlier of a puzzle. A puzzle will have many pieces, which if you look at only one piece may not make sense. However, if you put them together, they're going to make a much bigger picture, which is understandable. Just make sure the state that you are able to find all those pieces of puzzles, put them together so that at the end of the day, if you look at it, you say, this is the bigger picture, this is how things went on that fateful night, and the individuals that are in the accused box are indeed the one that committed the crime.
All right, Mr. Zikalala, it's always a pleasure having you with us here on SABC News. Thank you so much, sir.
Thank you very much.